Hello, everyone, and welcome to Uncivil Law. And today is a fairly serious and momentous day in the law. The Supreme Court has rendered a decision as it relates to employment discrimination on the basis of sexual orientation or transgender status, LGBT status, in other words. And by a 6-3 decision written by Justice Gorsuch, they have said that the 1964 Civil Rights Act in Title VII, which deals with employment, bans this kind of discrimination. And I think it's really interesting from originalist perspectives. I have skimmed both the decisions because it's 170 pages. Now, a lot of that is with some forms and stuff, but there's also a lot of commentary. And so I thought I'd discuss the syllabus of the decision, which renders out the majority's decision, and then I'd talk a little bit about some of the competing originalist ideas that the dissent has in mind, because I think they both the majority opinion and the dissenting opinion present some pretty interesting originalist arguments. And so they're really interesting from conservative grounds and originalist grounds in terms of how we think about these things, if you're interested in thinking about this in conservative legal mindset. So I think both opinions from the majority and the minority opinion reflect some decent conservative originalist ideas. The basic difference in substance is that the majority opinion goes much more into straight textualism, while the dissent tries to look more to original meaning and even potentially original purpose. But we'll get a little bit into that as we get into the decision. For now, let's just start with the syllabus and start with the main opinion and see what it has to say. So this is the summary of the main opinion from the Supreme Court. We're going to read this because it captures the decision, and we will see what it has to say, and then we'll talk a little bit about the competing ideas of interpretation. So we start with the phrase "in each of these cases" because this is three cases. This is three cases for the price of one. So there are three cases, two dealing with gay rights and one dealing with transgender rights, and they were consolidated by the Supreme Court. They thought they were close enough together, so they issued one opinion to deal with three cases. So we got three for the price of one today. In each of these cases, an employer allegedly fired a longtime employee simply for being homosexual or transgendered. It is essentially uncontested that that was their purpose. The employers have not denied it. Clayton County, Georgia, fired Gerald Brostock for conduct unbecoming a county employee shortly after he began participating in a gray recreational softball league. Altitude Express fired Donna Zarda days after he mentioned being gays. And RGNGR Harris Funeral Homes fired Amy Steffens, who presented as male when she was hired after she informed her employer that she planned to live and work full-time as a woman. Each employee sued alleging sex discrimination under Title VII of the Civil Rights Act of 1964. So that is the act that we're in. We're in the Civil Rights Act of 1964, and Title VII of that deals with employment status. And as we're going to see, bars discrimination on the basis of sex, but doesn't by its explicit terms bar discrimination on the basis of sexual orientation or transgender status. So that is basically a large part of what this dispute is. What does the word sex mean in the 1964 Act? And what was it meant to encompass, and what does it encompass? The 11th Circuit held that Title VII does not prohibit employers from firing employees because of being gay, and so Mr. Brostock's suit could be dismissed as a matter of law. The 2nd and 6th Circuits, however, allowed the claims of Mr. Zarda and Ms. Stevens, respectively, to proceed. So a classic ground for the United States Supreme Court to get involved. We have a circuit split. We have a difference of opinion between the lower courts. And so that's a classic ground for the United States Supreme Court to get involved. So now we have to figure out which of these two opinions is right, if any, because maybe it's a third option. But at least we have two courts that disagree. So is it one of these two, or is it some third option? Let's figure out. Held. An employer who fires an individual merely for being gay or transgender violates Title VII. Title VII, and here's the operative language of the law, so this is part that we probably should pay lots of attention to because we're trying to interpret this. This is what we as lawyers and judges are trying to do, trying to figure out what this means. Title VII makes it unlawful for an employer to fail or refuse to hire or to discharge any individual, or otherwise discriminate against any individual because of such individual's race, color, religion, sex, or national origin. Okay, so we got a couple things going on here. First, this is federal law. It applies everywhere. Your state law may also provide additional guarantees beyond this, right? So the federal law sets a floor, not a ceiling. So your state or state law may provide more than that. And some states do, by their own express terms, prohibit discrimination on the basis of transgender rights. But up until now, there was no federal claim. Now you have one, as of today, at least, to have a claim on your federal rights. So there's that. Second thing, what can't you do? Well, first of all, if you're an employer of sufficient size, and I forget exactly what the cutoff is, because it's been a while since I checked, but there is a cutoff. You have to be an employer of some size. I forget if it's 15 or if it's 50 employees. It's something in that ballpark, but it doesn't apply to the very smallest employers. So if it's just you and your wife and you're hiring someone to help run your store, then you can discriminate to your heart's content as far as the federal law is concerned. No problem, you don't have enough employees. But if you are an employer of basically any real size whatsoever, then this applies to you. You cannot refuse to hire an employee or discriminate against them or fire them because of this status. And this does not change whether or not your state is at-will employer. So I saw some people commenting in earlier chats that, oh, my state's an at-will employee. This doesn't apply. This is at-will. So this doesn't apply to me. This does apply to you. It absolutely applies to you. At-will allows your employer to fire you for any reason, but not these reasons. These are protected reasons. So yes, in general, your employer, if you're at-will, can fire you for any reason, or discriminate against you for any reason, or refuse to hire you for any reason, but not these reasons. These are protected reasons. So if they're discriminating against you for other reasons, you don't have a claim. If they're doing it because of these reasons, you do have a claim. So at will, not at will, doesn't matter. You know, you have, this is a protection that you have. Your employer cannot do this. The straightforward application of Title VII's terms interpreted in accord with these ordinary public meaning at the time of their enactment resolves these cases. So that is going to be a big dispute between the majority opinion and the dissenting opinion in terms of whether or not these terms, as understood in terms of their original meaning, counsel this result or not. It's really, really interesting in terms of that. So $10 from El Rojo Graham, thank you for the super chat, says, you said you wanted a change in employment. All those baseless discrimination lawsuits coming are probably going to be pretty lucrative, just saying. Thank you. That is a always encouraging suggestion. Maybe I should go into employment law because now I have an additional basis to do some stuff. Yes. So thank you, El Rojo Grande, for your support. It is, as always, extremely appreciated. Thank you. So as I was saying, yeah, the what this meant at the time and the original public understanding is going to be a huge issue, a split between the majority opinion and the dissenting opinion. So we'll get a little bit into that as we get further. Okay. The parties concede that the term sex in 1964 refers to the biological distinctions between male and female. Well, that's something that will make the conservatives at least kind of happy. So, and the majority opinion says this explicitly, and in the majority opinion, it says that by sex, we mean male and female, and only those things. So when Congress wrote the term sex, they meant male or female. You have only one of two options, and you're one or the other. Now, the transgender discrimination is going to come in not because of the transgender discrimination as such. It comes in because of sex discrimination, which is a really interesting tie. So we're actually, strictly technically speaking, it is legal to discriminate against someone because of their gay or transgender status. The reason the Supreme Court is coming out this way is because they say it's impossible to do that without also discriminating on the basis of sex. But there's only two of them. So you got that going for you. So that'll make the conservatives happy that you got that going for you. So yay. And the ordinary meaning of because of is by reason or on account of. Yes. Okay, so there's two things in the statute that's important. We can't discriminate on the basis of sex. That tells us what we can't do. But then there's also this in what way language or to what degree language, right? So it's additionally qualified. How can't we discriminate on the basis of sex? And the language the statute used is based on. And this becomes a pretty important aspect of the majority's opinion. The majority opinion would go on to say things like the Congress could have used words like the sole basis, right? So if it was the sole reason, that would give you protection, but they didn't use that language. Or they could have used the predominant reason or the primary reason or a substantial reason, right, to further qualify it. So they didn't use any of those choices. This also goes into why words matter. Words matter quite a lot in law. So what Congress wrote was based on. And what the majority opinion writes, and I think is quite right, is that means as long as it's a factor, it's enough. So even if you have other reasons that are legitimate, if it is in any way based on an illegitimate reason, it's illegitimate. So it could have been in an alternative universe that Congress said, well, if your sole reason for discriminating was on the basis of sex, then that's prohibited. But if you have other reasons, that's okay. So they could have written that. Or they said, well, if it's your predominant reason or your primary reason, well, that's not forbidden. But if it's only a secondary reason, well, that's okay. In some alternative universe. But what Congress actually wrote, and why words matter and how we do law in law world, they wrote based on. And what that suggests is if it's a factor, any factor will be fine. So if you have 9 legitimate reasons and 1 illegitimate reason, you're toast. If it's one of these illegitimate reasons. So yes, I fired you, both because you're a horrible employee and because of race. Sucks to be me. I can't do that. I could fire you because you're a horrible employee, but if one of the reasons I'm firing you is race, I can't rely on the fact that you're also a horrible employee. Can't do that. So if any of the factors are these things, it's a no-go. That term incorporates a but-for causation standard, which for Title VII means a defendant cannot avoid liability just because they cite some other factor that contributed to the challenged employment action. Yeah, all the other factors in the world are not going to help you. All the other factors in the world are not going to help you. If one of the reasons is because of a protected reason, that's not going to fly. And when we talk about but-for causation, what we mean is if it were different, would it have come out different? That's but-for, right? So if it were otherwise, would we achieve the same result or not? If the facts were different, would it come out the same way? If the facts are different and it comes out the same way, well, it's not but-for because it would have come out the same way. But if we change something and it would have come out a different way, that makes it a but-for cause, right? If it were different, it wouldn't have come out that same way. If that fact were different, it would have come out differently. Therefore, it's a but-for cause. So yes, if the person is black, if they were white, would it have made a difference? That's but-for. If the person is a woman, but they were a man, would it have come out different? That's but-for cause, right? If we would have done the same either way, and again, this goes a little bit into dissent in their view of the thing, if we would have done the same either way, then it's not a but-for cause. So that's what we're looking at when we're looking at that. Is this an essential aspect of it? Is this a required aspect of it? The term discriminate means to make a difference in treatment in favor of one compared with others. Yes, discriminate means what you think it means. Discriminate means to treat differently, for better or worse. So you can discriminate positively or discriminate negatively, but either one is bad. In so-called disparate treatment cases, the court has held this difference in treatment based on sex must be intentional. So that is a bit of protection for the employer. We have to be doing it intentionally. We have to be doing it because we don't like that reason. So if we're just doing it not intentionally, we might have some cover. Now, when something is intentional or not is a question of fact and is going to be tried by a jury or other trier of fact, right? Trying to figure out if it's intentional or not. So that's a factual question. But yes, in principle, if you are just discriminating on the basis of sex or race or whatever else, if you are in fact doing that, but it's not your intent to do that, you're covered. So yes, you can in principle discriminate unlimitedly if you're doing it in an unintentional way. But good luck in convincing your trier of fact that you didn't mean to do it. But in principle, yes, you have to do it. So again, this is law in theory versus law in fact. Yes, in theory, you can discriminate unlimitedly as long as you don't have intent. But is a jury going to believe that you didn't have intent? Good luck with that plan in the real world. A statute's repeated use of the term individual means the focus is on a particular individual as distinct from the class. So when we're looking to this, we're looking to each person individually and whether or not they were discriminated against individually, not in aggregate. Now, we can use aggregate data to help inform whether or not the discrimination against this individual is in fact a discrimination, right? So we can look to how people are treated in gross or in aggregate as a convincing evidence, if you like, as a suggestion. We can use it as a suggestion that this person has it out for some people of race or sex in general, right? So if every Black customer comes through their door, they turn away. That might be suggestive. That's discrimination on the basis of race, right? That's suggestive. But technically, strictly speaking, we're looking to the individual in question. So the fact that we turned away the last 10 Black people at the door has nothing, strictly speaking, to do with the 11th person. We have to figure out whether or not we're discriminating against them, in particular because of race. Now, this actually goes both ways. So even if we let the last 10 Black people in the door, if we don't let you in because you're Black, even though we let the last 10 people in because they're Black, it's also discrimination. So that goes both ways. It's both for good and bad. So this cuts both ways. So yes, strictly technically speaking, by the letter of the law, if I discriminated against the last 10 people because of race, but I didn't discriminate against you because of race, it's not invalid. But if I didn't discriminate against the last 10 people because of race, but I'm discriminating against you because of race, it is invalid. So the pattern is suggestive. It provides some color that would help to inform our decision. But technically speaking, we're looking at the individual, whether or not we discriminated against them. Again, these are questions of fact. And if you're doing against other people, a jury's going to take a look at that and be like, yeah, you're probably doing against others. But technically speaking, we're looking at the individual level. And that also can be beneficial when we're talking about this kind of discrimination, because one of the defenses an employer might try is, in general, in aggregate, I treat women the same as men. Right? So they might say, in the aggregate, I treat against men and women the same. But that's not a defense. If it's true that you discriminated against this particular person because of sex or race, even if you wouldn't normally do it, it becomes an unprotected aspect. So yes, so it protects the individual both ways. So even though in general I don't have a problem with race, for some reason in particular I decide to be racist against you, I'm unprotected. And if in general I'm racist, but I wasn't racist against you, I'm protected. So yes, technically speaking, we look at the individual level, which is actually very, very good for these particular defendants. Because one of the things the employer was trying to say was, well, in general, I'm nice to women, or I'm nice to men. In general, I treat men and women the same. It's like, well, the U.S. Supreme Court says, well, we don't care. We don't care that in general you're nice to men or nice to women, because that's not the right level of inquiry. The right level of inquiry is whether or not you were discriminating against this particular person because of race or sex. So aggregate data might be suggestive of that, but it's not dispositive. It's not dispositive. So if we can prove we discriminated against this particular individual because of race or because of sex, even if we don't in general discriminate because of race or because of sex, if we did it against you, we're toast. So it's actually very, very helpful to these particular individuals that we're looking at this on an individual level. So, before you think, well, that's really, really weird result, it actually really, really helped them, because if it had gone the other way, it would be actually a real problem. They wouldn't have been able to get where they want to be, because in general, they weren't having a problem. It was only with respect to specifically them. So the fact that it turned on specifically them is what exactly gave them their relief. So it goes to show you sometimes that things don't go the way you might expect them to go. So interesting. These terms in general, these terms generate the following rule. An employer violates Title VII when it intentionally fires or discriminates an employee based in part on sex. Yes, in part, because it's a but-for cause. Any amount will be fine because it's based on. It makes no difference if other factors besides the plaintiff's sex contributed to the decision. We don't care. Or the employer treated women as a group the same when compared to men as a group. We don't care. We don't care if you treat women the same in general or not. We don't care if you treat women the same, and we don't care if in general you treat women like garbage. If in general you treat women like garbage, but you treat this particular woman just the same as any other man, she doesn't have a claim. The rest of the women probably do, because they're being treated like garbage. But if for some reason you're treating this particular woman the same as you would any other man, she doesn't have a claim, whatever any else does. And if in general you treat the women the same, but for some reason you treat this particular woman differently because she's a woman, you're toast. So yes, we look to the individual ultimately when we're making these decisions. A statutory violation occurs if an employee employer intentionally relies on part of the sex when deciding to discharge or discriminate. Because discrimination on the basis of homosexuality or transgender requires an employer to intentionally treat an individual employee differently because of sex, and this is the contentious part of the majority opinion. This whole predicate here is really the big point of dispute, right? Or it's a major point of dispute. So the majority says because discrimination on the basis of homosexuality or transgender status requires an employer to intentionally treat an individual employee differentially because of sex, predicate, contentious, but predicate, an employer who intentionally penalizes an employee for homosexual or transgender also violates Title VII. Okay, so that is the key here. So again, technically speaking, in the strictest possible technical sense, right? In the strictest possible technical sense, it is not illegal to discriminate on the basis of trans status or gay status. In the strictest possible technical sense. What it is illegal to do is discriminate on the basis of sex. And because the Supreme Court says there's no way to discriminate against someone for being transgender or being gay without also discriminating on the basis of sex, discriminating on the basis of transgender or gay is discrimination on the basis of sex. So they're saying sex discrimination is a necessary predicate to transgender discrimination or gay discrimination. They're saying it's impossible to discriminate against someone because gay or because transgender without also discriminating against them because of sex. So that is the predicate here, because all we have is the statute. The statute only prohibits discrimination on the basis of sex. So if there were in principle a way to discriminate against someone for being transgender or being gay without discriminating on the basis of sex, then this doesn't hold. You know, we need that sex-based discrimination as the predicate to make this work. So if the majority's opinion is correct, that it's impossible to discriminate on the basis of transgender status or on the basis of gay status without also discriminating on the basis of sex, the conclusion holds. If that premise is wrong, the conclusion does not hold. So a lot goes into whether or not that premise is correct or not. So that's a major point of contention. There is no escaping the role the intent plays. Just as sex is necessary, a but-for cause, when an employer discriminates against a homosexual or transgender employee, predicate, contentious, but predicate, an employer who discriminates on these grounds inescapably intends to rely on sex in decision-making. So saying there's no way to sever these. There's no way to sever these. That's what the other side is trying to do. The other side is in large part trying to say these are severable. These are different things. The other side says I can discriminate on the basis of gay, and I can discriminate on the basis of transgender without also discriminating on the basis of sex. If you can do that, the dissent is right. If you can't do that, the majority is right. So can you do that or not? Yeah. And the one of the illustrations I like to bring into to illustrate this example is, here's your hypothetical example. I'm a covered employer. I have enough employees. I have two employees who we care about. Both employees decide to get married to men on the exact same day. But one of these employees is a man and one of these employees is a woman. I fire the man. Here's the question. Did I fire the man because of sex, because of gay, or because of both? That is an operative question here. So I had two employees, both got married to men on the same day. One employee is a man, one employee is a woman. I fire the man. Did I fire the man because of sex, because of gay, or because of both? That is the operative question here. If I can do it solely because of gay, I win. If I do it because of sex or because of both, I lose because it's based on that cause. So that is the question. Can I do it without also discriminating on the basis of sex? Yeah. Okay, so we have some precedent that might help inform this analysis, inform this idea as we're doing. So let's see what we've done in the past. 3 leading precedents confirm what the statute's plain terms suggest. In Philip versus Martin, a company was held to have violated Title VII by refusing to hire women with young children, despite the fact that discrimination also depended on being the parent of a young child and the fact that the company favored hiring women over men. All right, so we have a prior case. We like to hire women. We want to hire women. We hire lots of women. We think hiring women is the best. But we don't hire women and we don't keep women employed who have young children. Now, they argued, well, the reason is because they have young children. They need to be at home more and they're not as reliable, not as whatever. So we're not discriminating on the basis of them being women. We're discriminating on the basis of them having young kids. And the Supreme Court previously said, no, that's not going to fly. That's not going to fly. That's discrimination on the basis of sex, because you wouldn't do the same thing to a man. And, the data says that. And also women, at least by tradition, tend to be primary caregivers. So this has a disparate impact too. So, you're also looking at some Puritan ideas of what women should do and what men should do. So that's discrimination on the basis of sex. Okay, so they argued, oh, it wasn't because of sex, it was because of children. And they said, no, sex is a problem here. Okay. In Los Angeles Department of Water and Power versus Manhart, employers' policy of requiring women to make a larger pension fund contribution than men because women tend to live longer was held to violate Title VII, notwithstanding the policy's even-handedness between men and women groups. Right? Same idea. We're not discriminating because woman. We're discriminating because you live longer. Pensions are meant to be a thing that will continue on for the rest of your life. That's a typical pension, at least. It provides you some measure of your salary for the rest of your life. And because you live longer, we need more money. And so we're not discriminating against you because women. We're discriminating against you because you live longer. While that might be true in the aggregate, but it might not be true for any individual woman. And again, we look at these in the individual level, right? So even in the aggregate, it might be true, but we don't look at it in the aggregate because the language in the statute is not aggregate. It's individual. Individual discrimination is what we care about. So yes, in general, you're right. But as it applies to the individual, no, not so much. Okay. And in Onkyle versus Sundowner, a male plaintiff alleged a tribal Title VII claim for sexual harassment by co-workers who were members of the same sex. Yeah. So that is also a little bit interesting, right? So we will allow sexual harassment by members of the same sex. So male receiving sexual harassment from other male, right? We already had policies with women receiving sexual harassment from men, but we didn't allow it for men receiving sexual harassment from men. That's discrimination on the basis of sex, because we would accept the woman's complaint and not the man's. And so we were discriminating on the basis of sex. All right, that makes sense. Let's case on. The lessons these cases hold are instructive here. First, it's irrelevant what an employer might call this discrimination practice, or how others might motivate it, or what else might motivate it. Yeah, it is definitely irrelevant what you call it. And this is true many, many, many times in law. Many, 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 many times in law. Many times in law. And yeah, a lot of people try to use particular labels to get past things. And it's like, your labels are super duper interesting and all, but just because you call it a certain thing or a certain way doesn't mean it is that thing. You might be trying to put a particular label on it, but it doesn't mean that is that thing. This comes up quite a lot. In Manhart, the employee might have called its rule a life expectancy adjustment, and in Phillips, the employer could have accurately spoken of its policy as one based on motherhood, or more properly, parenthood. But such labels and additional intentions or motivations did not make the difference there, and they cannot make a difference here. When an employer fires an employee for being a homosexual or transgender, it necessarily intentionally discriminates on that individual in part based on sex. Contentious, but predicate. Second, the plaintiff's sex need not be the sole or primary cause of the adverse action. That's pretty good. In Phillips, Manhart, and Onkyle, the employer easily could have pointed to some other non-protected trait and insisted it was the more important factor in the adverse outcome. Here, too, it is of no significance if another factor, such as the plaintiff's attraction to same sex or presentation as a different sex from one assigned at birth, might also be at work or even play a more important role in the employer's decision. Yeah, query whether or not what this does for dress codes, for example. So if you have, because again, it's discrimination on the basis of sex, and the Supreme Court has made clear that sex means male and female. So if you have a bona fide occupational qualification and you require all men to wear a particular kind of uniform and all women to wear a particular kind of uniform, you might be able to continue to require a trans person to dress a particular way based on their at-birth sex, because you're categorizing it based on sex. Now you have to have a bona fide occupational qualification, so you have to have a reason you're doing it. But yeah, presumably you would still be able to do that. So if you have a dress code for all men and a dress code for all women, and it meets the required tests, you presumably could force a trans person to dress according to their biological sex, because then you wouldn't be discriminating on the basis of sex, because you'd be treating them as their sex based on what it was. And so that would presumably be legal. But I'm sure that will be a fight someday. But if you're an employer out there who wants to give that a shot, that might work. Final alert, an employer cannot escape liability by demonstrating that it treats males and females comparably as groups. Yes, we look to the individual. Yes, we look to the individual male, the individual female. Manhart is instructive here. An employer who intentionally fires an individual homosexual or transgender employee in part because of the sex violates the law, even if they're willing to subject all male and female homosexual or transgender employees to the same rule. That's a very contentious conclusion. It's a very contentious conclusion, and a huge part with the majority, with the minority split. When we get to the end of this, I'll try to describe more of the minorities' positions and their interpretations. But right now I'm just going through the syllabus, but we'll get to that in a second. The employers do not dispute that they fire their employers for being homosexual or transgender. Rather, they contend that even intentional discrimination against employees based on their homosexual or transgender status is not a basis for Title VII liability. Strictly speaking, technically correct, but not what we're looking for right now. But their statutory text arguments have already been rejected by this court's precedents. Yeah, we don't care if you're discriminating on the basis of, we actually don't care if you're discriminating on the basis of transgender or gay. We actually don't care. All we care about is whether or not you're discriminating on the basis of sex. So yes, I was discriminating against them because we're transgender and gay. That's super, super interesting. We don't care about any of that. Were you in any way discriminating against them because of sex? If so, then you're screwed. And because there's no way, according to the majority opinion, to discriminate on the basis of transgender or gay without discriminating on the basis of sex, then you're there. And none of their contentions about what they think the law was meant to do or should do allow for ignoring the law as it is, which, again, is a very, very conservative way of phrasing this, right? Conservatives, we'll get more into this as we get into the majority, but conservatives in general really don't care that very much about what the law was intended to do or its purpose or any of that crap. We really care about the text and what it means. So the purpose and their intent and a whole bunch of stuff, like we really don't care. So this is to my mind a conservative decision, and it's written in conservative language. This is conservative language I understand and accept. This is stuff that appeals to me as a conservative, right? We don't really care what Congress had in mind. We don't really care about their intent. We don't really care about their purpose. That's all super wonderful, interesting. What we really care about is the text of what they wrote. And when the text is clear, we do that. And that's all we care about is the text. We don't care what they wanted. We only care about what they did. So, what they did is what guides. And so, yeah, this has conservative appeal to me. I think the other side has conservative appeal too. I'm still trying to decide which one is better in terms of conservatism. I haven't quite made up my mind. I think the majority might have the better end of it, but I haven't made up my mind. We'll get into it. The employers assert that it should have made a difference that the plans would likely respond in conversation, that they were fired by being gay or transgender, not because of sex. Yeah, again, the label is not all we care about, right? So this again goes to what you put on the label. We don't care. We don't necessarily care about what you call it and what other people call it. That's super wonderful, interesting and stuff. But we look to what things are, not what you call it. So yes, the employer said, I did it because of gay. The employee said they did it because of gay. We don't care. That's super interesting and everything, but we really don't care. We're interested in what it is. So yes, the employee said because gay, but actually we don't care, because what they really was in reality was because sex. So yes, we look past the labels. The labels will not protect you, and the labels won't damn you either. So that's pretty cool. Conversational conventions do not control Title VII's legal analysis. Yeah, what you say and what is true in reality can and are different things. Which is simply whether sex is a but-for cause. Nor is it a defense to insist that intentional discrimination based on homosexuality or transgender status is not intentional discrimination on the basis of sex. That's contentious. An employer who discriminates against homosexual or transgender employees necessarily and intentionally applies sex-based rules. Contentious. Nor does it make a difference that an employer could refuse to hire a gay or transgender individual without learning that person's sex. That's really contentious. Yeah, that's really contentious because, you know, you could imagine a scenario where an employer would have like a checkbox on the application. Check this if you're gay, and wouldn't, for example, include on the form what sex are you. You could imagine the employer not including that because discrimination on the basis of sex is wrong. So the employer, as part of their application process, doesn't ask you what sex they are, or doesn't ask what age you are, or doesn't ask what race you are, or doesn't ask any of those things. But one of the things they ask you is check this box if you're gay, or transgender, or bi, or whatever, right? Check this box if any of those things are true. And if you check the box, they won't hire you. So they're not. So that would be an argument, right? We're not discriminating on the basis of sex because we don't care. We are discriminating simply because you're gay. Now, does that work or not? The majority says, yeah, you can't do that. The minority says we're not so sure. You know, if you're discriminating on the basis of gay or discriminating on the basis of transgender, you know, and if someone checks the box, you fire them, or no, you don't hire them. You're not discriminating on the basis of sex. So you'd be discriminating on the basis of a non-protected characteristic. You know. And also, incidentally, like if someone didn't check the box and you later found out they were gay, you'd be firing them not because of sex, you'd be firing them because they lied. So they lied on the form. So if they check the box, you fire them, and if they don't check the box and they are, you fire them because they lied, not because of sex. So that was the idea. Maybe we can do that. The majority says no. And this is also one of the reasons why I'm still trying to decide which side has the better end of it, because I'm still trying to decide the better end of it. If you are truly an employer who on your form, one of the things you says is, please check this if you're a felon, please check this if you're gay, please check this if you're transgender. And if someone checks any of those boxes, you don't hire them. And if you find out later any of those things are true, then you fire them for lying, regardless of sex. Is that the same thing as discrimination on the basis of sex? You know, this is partially why I haven't made up my mind yet as to which end has the better end of the argument on originalist grounds. Because like you could at least theoretically imagine an employer who's like, yes, I truly won't hire anyone regardless of if they're gay or transgender, regardless of sex. So yes, on my application, I absolutely ask. I don't ask what sex they are because I don't want to know and I don't care. All I want to know is if they're gay, and if they are, I don't hire them. So, you know, you could imagine that. So that's why I'm not quite sure which end has the better end of the legal argument. By intentionally setting out a rule that makes hiring turn on sex, the employer violates the law, whatever he might know or not about the individual applicants. The employer also stresses that homosexuality and transgender status are distinct concepts from sex, which is a reasonable argument. And if Congress wanted to address these matters, it would have made so reference explicitly, specifically, which is a pretty good argument because Congress, in many other statutes, not here, not in employment, but there are many other statutes in which Congress has added transgender and gay status as a protected reason. So not in this statute, but in other statutes. So that's a pretty good argument, right? If you're the other side. It's like, well, you know, Congress, if they want these things, knows how to use these things. And they didn't use these terms, so they didn't want these things. You know, when Congress wants these things, they know how to use them. So, but you could of course make the argument that they were actually there the whole time. And when Congress added these things, they were merely clarifying what was there already. So they weren't actually like amending the law. They're just clarifying what was already true. But, you know, that's an interesting argument. But when Congress chooses not to include any exceptions to a broad rule, they apply the broad rule. That's true, yeah. So if we don't have something specific, we apply the broad. Finally, employers suggest that because the policy issues have the same adverse consequences for men and women, a stricter causation test should apply. That's not going to fly. They argue, unavoidably comes down to the suggestion that sex must be the sole or primary cause. Yeah, that's not going to fly. That's not going to fly. So a stricter causation test, no. That's not going to fly. But if we can prove that it's not discrimination on the basis of sex, we're there. But stricter causation test, no, that's not going to fly. The employers contend that few in 1964 would have expected Title VII to apply to discrimination against homosexual and transgender person. Yeah, which gets a little bit into the dissent idea and who has the better end in terms of being conservative and originalist. Yeah. But legislative history has no bearing here when there's no ambiguity about how Title VII's terms apply to the facts. Yeah, the conservatives hate legislative history. We really hate legislative history. We're not interested in legislative history because it doesn't speak to what Congress wants. It speaks to some members of Congress what they thought. So yeah, the legislative history to a conservative were like, get away from me, Satan. We don't care about any of that crap. So yeah, we're just going to go with the text and what Congress actually wrote and what it does or does not say. While it's possible, a statutory team, this is good to take note of in terms of interpretation in general. So it's not really so much important to this case, but it's important in general. So take note of this, as you're looking at things. This is a good interpretive note. While it's possible a statutory term or a constitutional term or any term, while it's possible a statutory team means one thing today, or in one context might have meant something else at time of adoption, or might mean something different in a different context. The employers do not use historical sources to illustrate that meaning, that the language has changed, or some ordinary term. Yes. So to a conservative, this is super, super important. This is very important. This is like all the important, right? So we look to what the word meant at the time it was written, not what it means today, which is also like a conservative critique of this, that they think that the majority is improperly doing that, but we'll get into that. But we don't look at to what a word means today. We look at what it meant at the time, because words, and we look what it means in different contexts. So yes, it is possible that the same word in two different statutes passed at the same time might mean two different things, or even in the same statute for that matter. If context makes it apparent, right? You could use the same word in two different ways in the same statute even. But from context, it makes it clear two different meanings are apparent. So yes, to a conservative, you do not use whatever it means today. It means what it meant in 1964 and nothing more. It is frozen in time. If Congress wants to change it, they can use a different language. Or for that matter, theoretically, they can use the exact same language. So yes, Congress can theoretically pass the exact same statute today, and it would mean something different today than it meant then, because the word could mean something different now than it meant then. So yes, we look to what the words mean. So yes, Congress can write the exact same thing now, and it might mean something different because words change. So that's what that's talking about. So that's a very good interpretive note for conservatives everywhere. Instead, they seem to say when new application is both unexpected and important, even if it's clearly commanded by law, this court should merely point out the question, refer the subject, and decline to support the law's plain meaning. Yeah, no, that's not how a conservative thinks. For better or worse, that's not how a conservative thinks. Whatever it means, it means. Whatever its application is. Even if it's an unexpected application. Congress should learn how to law better. This is not our problem. Congress should learn how to law better. So even if it was unexpected at the time, that is not important to a conservative. Now, we'll get a little bit into why that may or may not be interesting in terms of the dissent. But this is also very Gorsuch. So if you know anything about Gorsuch and you know anything about his confirmation, Gorsuch writing this makes total sense. Because if you know anything about Gorsuch's confirmation, you know that he got raked over the coals during his confirmation because of this trucker case. So there was a trucker who was driving along the interstate in very, very cold conditions, and his truck crapped out or something, and he was told to stay in place and essentially freeze to death by his employer. And he decided not to do that, and his employer fired him, and he brought suit. And Justice Gorsuch, when he was then Judge Gorsuch on the Court of Appeals, Judge Gorsuch wrote an opinion basically denying the trucker his relief, because the way the statute was written by its clear language did not provide an exception to the trucker, which seemed absurd because there was other language in the statute that, if other things had been true, it would have protected the trucker. And it seems like, this is a natural extension. But Justice Gorsuch doesn't think that way. So Justice Gorsuch said, no, that trucker does not get relief because of the exact language that Congress wrote. Their purpose and their purpose and intent is super interesting and all, but what they actually wrote in their actual words is not what Congress what they're trying to do now. So Congress might have wanted this to be protected, but this trucker loses. So yes, the trucker was apparently supposed to stay there and freeze to death, and because he didn't do that, yes, he can be fired. Horrible result, but it makes sense when you read the exact language of the statute. And here, Gorsuch is doing exactly the same thing. So for all you people who were super duper critical of Gorsuch in the ICE trucker case, Gorsuch is just doing exactly what he did then. He's like, I don't care about the results. I don't care about the results. I don't care about Congress wants. I don't care about their intent or their purpose or anything. All I care about is what they wrote. I don't care that they didn't see this result. I don't care that they didn't want this result. I don't care about any of that crap. All I care about is what they wrote and the application thereof. So this is as much Gorsuch as that ICE trucker case. You know, Congress wrote one thing in that ICE trucker case. This guy loses because of what Congress wrote. That may not be what they wanted. It may not be their purpose. It may not be their intent. It might be a little bit ridiculous, but it's what Congress wrote, and Congress wrote it, and that's all. And by the same token, he's doing exactly the same thing. So you can't say Gorsuch isn't consistent. He's being very consistent in his philosophy. He is applying his philosophy extremely consistently. Congress may not have wanted this. They may not have intended this. They may not have been this purpose. It may not have been anything they saw about. It may not have been anywhere in the back of their minds. Do I care about any of those things? I do not, because I'm Justice Gorsuch. I do not care about literally any of those things. All those things are super, super interesting and all, but I don't care. All I care about is what they wrote and the application thereof. So, you know, this is very Justice Gorsuch. It's very Justice Gorsuch. So, you know, yeah. This court has long rejected that sort of reasoning. Well, Justice Gorsuch definitely does. And the employer's new framing may only have problems and leave the court with little more than little law to overturn. Finally, the employees turned to naked policy appeal, suggesting this court proceed without law's guidance to do whatever thinks best. This is an invitation no court should ever take up. Yeah, let's not ever do policy ever. This was written by Justice Gorsuch, along with Justice Roberts, and the more liberal justices, Alito, Thomas, and Kavanaugh dissent. Okay, good times. So yeah, compile code from legal English run. Yeah, I like that very much, Barney. I forget. I think Leonard said that earlier on history, but I like the analogy very much. Yes, this is just, you know, Congress wrote it. Let's just compile it and run it, man. Whatever it says, man, just learn. You know, learn to code. Learn to code, Congress. Learn to code. We're just the compiler. Don't blame us, man. Learn to code. Yeah. So I think it's very, very true. All right. So let's talk a little bit about the what about the funeral home cases? This was all consolidated. So this is a 3-for-1. So this was all 3 cases in one. So they all come up exactly the same way. It's one opinion for 3 cases. So the funeral home case, the baseball case, and the whatever. Yeah, they all come up the same. So it's a 3-for. So yeah, same result, same analysis, same case. 3 cases in one. Done. All right. Yes, I know about the being careful with learn to code. That's why I'd be a little bit flippant with it, because yes, learn to code, Congress. Yeah. All right. So the funeral home was about a man that wanted to dress as a woman. Yes, but the same analysis. It's discrimination on the basis of sex. So yes, it comes out the same way. The Supreme Court says that whether or not you're discriminating because gay, or whether or not you're discriminating because transgender, you're discriminating against a person because of sex. Now, query again on the uniform issue. So if they truly had a uniform issue, because I don't think the home actually had a uniform issue. I don't think they had a uniform established in their case. So there might be a point here. There's a little bit subtle point, but I'm not sure the facts are such that it would turn here. But if the funeral home truly had a policy where all men in the funeral home dress this way and all women dress this way, and they truly had a dress code, and they truly were trying to insist on a particular dress code based on biological sex, you might be able to come out differently. I'm not sure the facts are there to do that for the funeral home case. I'm not sure it was that well delineated in their policies. So there might still be some avenue here if you're a company and you want to say, here's the men dress code and here's the women dress code, and we want to treat a transgender person based on biological sex. So we're treating, if they're a woman, for example, or a man, we're treating them the same as all men. So they have to dress this way in conformity to all men. So you might be able to do that, but in the funeral home case, I'm not sure that the facts and the predicate were there. So it seemed to be more of an ad hoc. So I'm not sure the facts were there. But yeah, you might be able to do this differentially if you had a well enough written policy. And you'd have to show some bona fide reasons for doing that, probably still, but there might be some avenue there. But anyways, yeah. Well, Greg says it was, but I don't know the case that well. I don't know the facts that well to know whether or not that's true. But if you think that's really the case where it was well specified and everything, then maybe it comes out a different way. But it's they seem to be saying, well, we're firing you because of transgender status, rather than, at least the Supreme Court says that's true. The Supreme Court says that they were firing them because of transgender status, and that was improper, not because of a dress code violation. So there might be a different analysis there, but I don't know the facts well enough to agree or disagree with you. Anyways, so let's talk a little bit about the dissent, and let's talk a little bit about the conservative principles and conservative application of law, and I'll try to figure out which one makes more sense to me as a conservative. So we have a couple things going on when we're thinking about conservatives. First of all, we have straight text, so we have textualist. So this is very textualist in nature. So this is more about black and white text rather than anything else. But conservatives also tend to think about what terms mean when they were written. So we look to terms and we look to what they mean when they were written and what their application is, for better or worse. So like the word sex in 1964 meant male or female, one of the two. And that's our interpretation, right? So we're discriminating against sex. If we treat a male differently than we treat a woman, we treat a woman differently than we treat a male, right? So that's what we're interested in, is that we're treating a person differently because they're male or because they're women. So how does that so the dissent looks to some of the ideas of language, and it's like, well, no one in 1964 had this in mind. No one thought it included gender or transgender. So I think the majority has the better end of that argument, because again, using it in 1964 is just an application of what it meant in 1964. It meant discrimination on the basis of sex. So that part, I think the majority has the better end of. The question is whether or not you're discriminating on the basis of sex when you discriminate on the basis of gay or the basis of transgender. That's really the operative question. And so it goes back to that hypothetical I raised earlier when we said, I as an employer, I have two employees. I have two employees, both get married to a man on the same day. One employee is a man, one employee is a woman. I fire the man, but not the woman. Did I discriminate on the basis of sex or not? Well, I fired the man, but I didn't fire the woman. So I fired the man because he was a man, where I wouldn't, both married a man. So I fired the man because he married a man, but not the woman because he married a man. So I discriminated against the man because he was a man. So there's that idea. But there's also the idea that no, well, if I fire all women who are gay, then maybe that's different. But then again, I'm firing those women because they are engaging in behavior that's inappropriate for their sex, but appropriate for the other sex, right? So, one sex is doing something. Well, both sexes are doing the exact same thing, and I'm discriminating against one of them and not the other, even though I'm discriminating against men and women both. So even if I'm an employer who is firing both men and women because they're gay, I wouldn't have fired them if they were the other way around. So yeah, I fired both the man and women because they're gay, but I wouldn't have fired them if the man was a woman and the woman was a man. So therefore, that's sex discrimination, not gender discrimination. So there's that. The and I'm also, even in the, and the majority also has this idea that even in the blind application form, so even if I'm an employer who has an application where it's check this because if you're gay or transgender, even if I don't know their sex, I don't have to know their sex to discriminate on the basis of sex, which is an interesting idea from the majority, right? I don't have to know your sex in order to discriminate against your sex, because I'm discriminating against you because of behavior that you're doing that I wouldn't discriminate if you were the other sex or sex. So I'm not discriminating. So even though I don't know your sex, I'm still discriminating on the basis of sex, because if you were the other sex, you wouldn't be gay, right? You wouldn't be gay or transgender. So if you were the other way around, you wouldn't be those things. So I'm discriminating on behavior that you have based on your sex. You're not gay if you're the other sex, right? You're only gay if you're the same sex. So yeah, it seems to imply discrimination on the basis of sex. So I think the majority has the better end of it. I think the dissent though has a pretty good argument, and I don't think it's a pointless argument. I don't think it's even bad faith argument. I just don't think I think the majority has the better end of it, because it's hard to imagine a scenario, even a theoretical one, where I'd be discriminating on the basis of gay or transgender without also discriminating on the basis of sex, because it's I'm discriminating against you where I wouldn't discriminate the other way around. So there's that. So I think gay makes it a little easier, because gender and sex are different concepts. So I think the analysis for gay makes a little bit more sense than transgender, because a transgender is really trying to. I know we don't use terms like transsexual anymore, but they're essentially trying to transition their sex, right? So they're trying to transition sex, so transsexual, but we don't typically use that language anymore. Um, but the idea that gender and sex are a little bit different is even codified in law. So I think it makes a little bit more sense for the gay versus the transgender, because I it makes a little bit more sense, but I still see how the majority gets there. But I think the dissent has some pretty good ideas, and I think they are looking at the way sex was understood at the time, and also, like, as I might be mistaken on this, but I think when they first wrote sex-based discrimination, it didn't even cover pregnancy or something. I think that had to be added. So like even the idea that it covered pregnancy wasn't implicit, So they were looking at something a little bit more specific when they wrote that language. But the problem with that, the problem with that again, is you're looking to what Congress intended or their purpose. So even if Congress, assuming arguendo, even when they wrote it, they didn't intend to cover pregnant women. So they were thinking, oh, you shouldn't discriminate on the basis of sex, but if they're pregnant, that's okay. Even though that's like implicitly one sex or other. Even if that's what they were thinking, what they actually wrote was sex. And so, like, well, you would discriminate against the woman for being pregnant, but not the man. And it's true that only women can be pregnant, but still, you're basing it on a sex-based thing. So yeah, that's. So to me, I think the majority has the slightly better end of the analysis. I don't think it's overwhelmingly better. I think it's a closer call than a lot of people are giving credit for. I think it's a very fascinating legal issue. I was listening to Ben Shapiro earlier today, and Ben Shapiro massively disagrees with me. Ben Shapiro thinks it is completely unsupported from conservative and right-wing principles. He thinks it's completely an abomination. He thinks it's legislating from the bench. So he disagrees with my analysis. But if you think about like what it means to discriminate on the basis of sex, it's like, yeah, I'm treating a man differently because he's doing things that only women should do. And so that's discrimination on the basis of sex. Now, I think Ben Shapiro has some pretty interesting points that he made on his show earlier today. There's the issue of dress, which I brought up, and so I'm not sure how that comes out. If you have a dress code and you insist on men dressing a certain way and women dressing a certain way, I think that might be okay, but I think that's an interesting question. Um, if you are around the office and you're saying things like men are men are men and women are women, and another employee hears that, is that a hostile work environment for you to have that opinion or express that opinion? That's an interesting question. He also made a point of like, how does this impact closely held businesses? Because again, I forget exactly what the threshold is for this statute. I forget if it's 15 or if it's 50. It's like one of those numbers. But yeah, what about businesses with 100 employees? Like, what about Hobby Lobby? How does this apply to Hobby Lobby or not? Does the Hobby Lobby decision, which deals with birth control on closely held corporations, does that still work here or not in terms of closely held corporations? And how about religious organizations? Presumably straight up churches and straight up religious organizations are still exempt because they're exempt under a different law, so they're okay. But maybe a Catholic hospital can't do this in terms of how they do it. So there's some interesting questions on the periphery that are not answered here. And also, it is a fair criticism that Congress has been trying to do this through statute and been unable to do it, and they have put it in other places. And so you are doing something that Congress has been trying to do and unable to do, and now you're doing it by legislation. So there is a point to be had there. But I think from straight up originalist principles, I think this is supportable under originalism. I think when you think about, well, what does it mean to discriminate on the basis of sex? Well, sex means man or woman, right? I can't discriminate on the basis of sex, so I can't treat a man differently than I can treat a woman. I can't treat a woman any different than I treat a man. And if I'm firing a man because he's gay, I'm firing him because he's doing things that women can do, but he can't do, or vice versa. So I think it's originally supportable. I think the other side of this, where they're looking to, the other side is looking a little bit more to original purpose and original intent and original public, because they're even looking to original public understanding. But the problem that the dissent is having is they're kind of looking to the original public understanding of the statute as a whole rather than the term sex. So, like, yeah, it's true that no one in 1964 presumably was thinking gay or thinking transgender or thinking any of those things. But yeah, this is just like, well, what they were thinking about was men and women, and not discriminating on the basis of that. And it's like, well, even though the concept of transgender hadn't even entered your mind yet, when you apply it logically, it's supportable. So it seems very Justice Gorsuch-esque. I think it's supportable from original's point of view. I think the other side has some interesting arguments. They seem to be looking to the original understanding of the statute as a whole, rather than the term sex and what that actually means as a term. So they're trying to look at original's understanding of the thing as a whole, which I don't think is invalid. I just think the majority has the better end of it. I think the majority's opinion is probably better. So I wouldn't say that I'm sold on the majority opinion, but I am leaning in the majority opinion. I lean on the majority opinion because, it's not a big surprise because I like Justice Gorsuch. He's my favorite current justice. And so it's not a huge surprise that I would support a Justice Gorsuch opinion, because the man can write. He makes me sad at myself because I can't write anything close to as well as he can write. It's like, man, geez, I wish I could write like that. Damn it. Yeah. Another issue where this is going to pop up, by the way, is in education, because Title IX deals with education, and Title IX prohibits discrimination on the basis of sex. And it is often the case, not always, but often, that Title VII, dealing with employment, and Title IX, dealing with education, wind up informing each other. So I would not be surprised, and in fact, I would be surprised if it didn't. My expectation would be courts, in interpreting Title IX, dealing with education going forward, will apply this. There's no obvious reason not to, so I'd be surprised if it come out differently. So I think Title IX and dealing with education will now be read this way. Do I think this will impact quotas and affirmative action in the future? I don't know. Yeah, I don't know about that, but it's good stuff. So I don't know how this is going to inform things. I'm particularly concerned with the hostile work environment. I'm concerned with how this, again, as an employer, how does this impact me if a especially in the case of trans, so in a male to female, should I use the pronoun she or the pronoun he? Presumably, I mean, I don't know how that comes out, because if I call all men he, and you're a man by birth, so I'm treating all men the same. So I'm specifically not discriminating against you on the basis of sex. I'm calling you specifically he because you're also a he. Is that a hostile work environment that's improper, or is that proper because I'm treating all men the same based on biological sex and biological birth? So I'm not sure how that comes out. I'm sure that'll be an interesting fight with the hostile work environment stuff. So that's an interesting one. Thoughts on Justice Thomas? I mean, Justice Thomas joined Alito's opinion. So Justice Thomas didn't write a separate opinion, as far as I could see, unless he did. So, but yeah, I think the majority has the better end of it. Yeah, and then in terms of the sports issue, that's also interesting. What it means to discriminate on the basis of sex, whether that means what that means for trans athletes. That's a really interesting one. Again, Title VII and Title IX tend to inform each other, but that doesn't necessarily always apply. So it would be interesting to see how that deals with trans athletes. Yeah. I saw that Moira's been growing on me, so give it time. Fair enough. Yeah. So that'll be good stuff. So yeah, it'll be interesting to see what this does in Title VII. It'll be interesting to see what this does in Title IX in sports, in terms of how that impacts things or not, in terms of the segregation of the sexes. So that'll be interesting to see what it does in sports. So yeah, the courts in Title IX world had their life made more complicated by this decision. So good times. It could come out differently in Title IX, but it's going to be raised by many, 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 many people. So I think that's pretty interesting all the way around. Very, very interesting decision, very informative decision, and I think a conservative decision. I think the other side has some good merits too, though. So I think that at least Ben Shapiro might have it wrong on this one, saying the other side is essentially garbage, because I don't think it's that easy. So we will see how it goes. For the 45 of you who are here, if you like the stream, if you'd be so kind as to give it a like, I would very much appreciate it. As always, if you're not a member, if you'd like to join, hit the little join button. You can get your name in green, and then I will like you more. And we have a Discord that we are trying out on a trial basis. So let me get the link for that, which is somewhere. And you can join my Discord and all that stuff. Does this apply to contractors and subcontractors? I honestly don't know for sure. Presumably, well, contractors are still employees of somebody, so it would apply in so much. It would apply at least in so much as the person who's hiring the contractors would. So so if you're saying, does it apply to Uber or something like that, then that's a more interesting question. I'm not sure how it applies to something like that, but yeah. Yeah, I joined it, but it doesn't seem all that useful. I agree. It's not all that useful as of yet. It really hasn't grown and developed that much. We're still it's a new Discord. So we're trying it out. I agree it's not all that useful right now. I'm hoping that more people will cause more chat. I'm hoping to create more subgroups in there. I don't want to create them unnecessarily though, so I'm trying to keep it at a minimum right now in terms of stuff. But yeah, I'm hoping that it will develop into something. So we're giving it a try. If it doesn't work, we'll abandon the whole thing and pretend it never happened. But we'll see how it goes. I didn't see about Michael Moore's thing being discriminated against. Yeah. Oh, you mean you didn't you didn't see the benefit of joining as a member? It's mostly just to show support of the channel. It's 99 cents. So I mean, if 99 cents is too much money, I understand, but yeah, it doesn't really have much benefit. It's mostly just to show support. So yes, it doesn't come with a lot of perks. That is true. So yeah, if you wanted more perks for your 99 cents, then okay. You post to everyone. I get an email saying you mentioned me. Yes, I post to everyone. Should I just do at here? Is that different than everyone? Um, I don't know how that works in terms of notifications. Um, yeah, for 99 cents you can become a member of the channel. You hit the join button and you get your name in green. So somewhere on their screen, somewhere near the subscribe or where it used to be, there should be a button labeled join. If you press that button labeled join, you can join for 99 cents a month, and you too can become an uncivilian, and it will be cool and stuff. Yes. Yeah. So we are looking into that. So we'll get back to you. Anyways, hope that's all for later, my friends. I hope this is entertaining. Peace and goodbye.